Let's move to this, Oregon. That was the scene in Portland over the weekend, protests spiraling into violence near an ICE detention facility. This as an appeals court has ruled in favor of the White House and President Trump, saying it can deploy the Oregon National Guard to the city. Former prosecutor Jim Trusty here. And Jim, good day to you. I got two questions on this, but first, the Oregon governor, Democrat, strongly against this, said this after the ruling from the court. Watch here.
Oregon remains united in the fight against this unwanted, unneeded military intervention in Oregon. We're going to continue to show up for our neighbors, make our voices heard, and use our collective power to protect our communities and our democracy. I still urge the Trump administration to send all the National Guard members home.
Okay, you've got that. It's unclear to me in reading about this whether you can only send state National Guard troops that apply to that state, or you can draw other Guard troops. Do you know what that answer is?
Yes. I don't know for sure, but it seems like it's open to pull them from wherever. I mean, basically the authority, the permission slip for the president that they've been given is that if you need to back up federal law enforcement by having the National Guard come, you can do so even if the governor objects to it. So the key is that issue of are they needed to protect federal law enforcement functions. And Portland and the politicians there have been completely dishonest. They've made it a summer of love story where they say everything's fine, there's no problem, ignore the guillotine over there on the right, don't worry about the lasers being pointed in ICE agents' eyes, we've got it. And I think the appellate court finally saw through that. And they basically said we're not going to keep wading into this kind of ambush emergency litigation brought by political folks that are opposed to the National Guard showing up.
It's a significant win for the president.
The idea of where the Guard comes from.
Yeah, significant win for the president. The ruling came out of the Ninth Circuit. Jim, just not too long ago, if you were pushing a liberal policy in America, you went to the Ninth Circuit to win. That court has changed.
Yeah, it has. I mean, and it was always the most reversed circuit by the Supreme Court for many, many decades. But Trump won in that first administration. He had a lot of turnover in the Ninth Circuit, and he and Mitch McConnell moved things along quickly and got a bunch of people appointed. So now it always comes down to the draw of the three that are hearing your case. You might get 2 or 3 conservatives, you might get 2 or 3 liberals.
Jim, let's move to James Comey. Late yesterday afternoon, he filed a motion to dismiss the case against him. Here's part of what he's arguing now. He says the government has singled out Mr. Comey for prosecution because of his protected speech and because President Trump's personal animus toward Mr. Comey. Such a vindictive and selective prosecution violates the First Amendment, due process clause, and equal protection principles. You got a lot to say about this. Go ahead. What do you think?
Sure. I mean, look, selective and vindictive prosecution, that's the angle on that particular motion. Those are both uphill concepts in general for defendants to get a dismissal. And I don't think it's really that different here. You know, selective means you have to show a track record of similarly situated defendants. I don't know how you do that with an FBI director lying to Congress. We don't have like 10 other circumstances where people were not prosecuted for it to point to. The vindictive is all the stuff you thought it would be. President Trump's comments, you know, putting Lindsey Halligan in office. It's all the kind of political stuff that's out there. Again, I think that's uphill to lead to a dismissal. The sleeper here, the motion that concerns me, is the one about the authority of the interim U.S. Attorney, Lindsey Halligan. And that's an issue of basically saying, look, the president has the right, if there's a vacancy, to put somebody in for 120 days. After that, the power kind of shifts to the court to name an acting U.S. attorney, all of which being just a quick substitute until somebody gets confirmed by the Senate. Problem here is Eric Siebert served for 120 days. Lindsey Halligan comes in, does the indictment herself. So the question is, can you keep stacking interims? And that's the same issue that broke against the administration with Alina Habba's appointment up in New Jersey. And frankly, it's a little bit of the same issue in a sense of Jack Smith's dismissal in Florida, that if you don't have authority to be the prosecutor, your case is a nullity. And here's the kick. If it's a nullity, you can't go back and fix it because the statute of limitations has run. So I'm very nervous that this motion, which sounds kind of tepid, is actually a sleeper where we end up seeing a a Jim Comey courthouse steps victory lap, which would be kind of a bitter pill to see.
Interesting.
But he's got some pretty good arguments there, and it'd be interesting to see how they respond.
Great analysis, Jim. Thanks for sharing that with our audience. Really appreciate that. Thank you.
Sure, good
Talk
to see you
soon.
guys.
Thank you, Jim Trusty.
I'm Steve Ducey.
I'm Brian Kilmeade.
And I'm Ainsley Earhart. And click here to subscribe to the Fox News YouTube page to catch our hottest interviews and most compelling analysis.